attributed to a lack of sufficient medical practitioners and infrastructure in the health sector. We all know this is a very big problem that we are having in Nigeria. But despite the alarming number of victims, we have noticed that there has been a low level of formal complaints or even lawsuits for compensation. Number one is ignorance. The other one is poverty. And in some cases, patients or the victims, the families are reluctant completely to seek redress against the offending medical practitioners. Unlike in developed countries, the quality of medical practice and care for patients is higher because there is a sense of accountability required from every medical practitioner, which is not obtainable here. I'm not saying that there is no regulatory body. No, there is, but I'm not sure there is enough enforcement of those acts. You ask another question: how easy is it for the patient to seek redress and get adequate compensation? That's a big problem. In Nigeria, we have a situation where you have patients who are not even aware of their rights, talk less of knowing that they have to seek redress, or maybe knowing that they are offended. And as such, they cannot appreciate when there has been any breach or anything, not to talk of, just taking it a step further by seeking redress, like I said. One of the major challenges faced by the patient, even when you advise them, because they will say within Nigerian context, there is this cultural attitude towards litigation. It's viewed as a last resort. Most Nigerians do not embrace litigation due to the problem of delay in judicial process, and also corruption, and also the high cost of litigation, which is also compounded by the poverty in the land, the complacent nature of the average patient, and high level of poverty. Patients are left with no other choice than to leave their fate to God. It's not easy to establish medical negligence also in the courts in Nigeria. Just also have in mind that the courts will rely on the expert evidence of other medical personnel who may be reluctant most of the time to give evidence against their colleague. Being the average Nigerian, we have this belief that doctors can only treat and God heals. Thank you.
Thank you so much. And I'm particular that you mentioned that, we need expert evidence in court, and that sometimes it appears that medical professionals are reluctant to give evidence. So do you think that, there might be an issue within the profession of shielding their members for them to avoid liability? And if so, are there any mechanisms you think we should develop to prevent that from happening?
I don't think so. That there is any, that in the medical profession, that they would like to shield their members, or help them to avoid liability. No, it would be wicked of me to say so, because we are talking of human lives here. But we have, for example, Nigerian Medical Council, which is vested with powers to enforce discipline amongst every members through their medical practitioners disciplinary tribunal. But the problem, like I said before, is that of enforcement. Are there effective mechanisms within the Act for the close monitoring of these practitioners by this council? Because many of the times when breaches are experienced, the enforcement, is not there. If you go to complain to the council, even sometimes months, your file or your complaint is not even attended to. So we have experienced it several times with some, affected patients and their families. So I'm not sure it's from the medical council, but or from the, that there is a plan, just not to enforce it, but there is no strict enforcement on these guidelines. It's not really seen at all or observed.
Okay, thank you so much, Engineer Okwuolisa. And I see Dr. Onyia has a hand up. Madam, if you just give us a second so that we can get Dr. Muoghalu's comments, and then we'll come back to you, because I'm sure you want to respond on the issue of shielding medical professionals shielding their members. So, Dr. Muoghalu, you have international experience of what we're talking about in medical law negligence. And I was wondering, from your experience, from the international perspective, and then also having experience in Nigeria, what internal structures would you suggest that we adopt in Nigeria to combat some of these problems of medical negligence that we're experiencing in the country?
All right, thank you very much. Thank you very much for this opportunity. I will make my point in two folds. One is to be able to throw a little bit light on the structures being put in place in Nigeria, and also being able to relate that to some of the places I've provided support services to government, enabled to strengthen their laws and set up systems for to be able to deliver patient-centered care. Now, what we have here is, in Nigeria, we have the Medical and Dental Council that oversees the aspect of professional ethics of medical doctors and dental surgeons. Now, there is a professional discipline department within the Medical and Dental Council. What is missing is the public doesn't have a lot of information, and I agree with what the last speaker spoke in terms of understanding the workings of the Medical and Dental Council. They are the one that gives a license to anyone to say you are competent enough, but also they also tell you that on a yearly basis, you need to renew your license in order to continue that practice. So these are the two, this is what is obtainable in Nigeria. But what also that is missing is the public are not fully informed in terms of how to seek redress. That is why you see issues with relation to medical negligence or medical error being put out in public court or social media. Social media has helped to amplify the awareness of people, but also what it has not done is showing people how to follow, what to do when you want to seek a redress. Now there is the my knowledge of Nigerian Medical and Dental Council is if there is a medical error or medical negligence issue, an investigative committee or a panel has to sit on that case. The number of people on this is about 15, I think so, but they are quite few to handle the case, the whole case within Nigeria. So you have people there, and all these people are, from my knowledge, I know these are all medical practitioner, medical and dental practitioner of good standing, but also they have law degree. So they are not just doctors, but they are doctors, and a quite number of them are lawyers. One thing that, well, now when you compare it to what is obtainable in the US and in the UK, I'll speak for US, where some of the organizations have worked, and in Geneva, you tend to have people, the public, being very informed in terms of how to follow the procedures within a health facility. In fact, the public being provided with information on how to seek redress if you have any issues with any health professional in that facility. This information is not readily available. So that is why you see people moving in, they don't get that information very easily in a health facility. Then sometimes, because of inability to get this information, it appears as if people are shielding their own. So this is something that is very, very disturbing for the public in terms of seeking redress, whereby the way the system is being put in place, it's not easy for one for a prospective for a victim to get the right redress. And it's important to be able to clearly say this, because when it comes to medical practice, medical malpractice, medical negligence, or medical error, there are a certain level of justification that is required, which says this person has provided a substandard care, or this person has provided a care that caused an injury to a patient. So you should be able to provide reasonable information to justify that the care was substandard, the care was the cause of the injury. So these are some of the things. So again, a lot of work, I have supported, a quite number of other West African countries, and you could see that even in some other West African countries, Nigeria is not yet there, but they've done well in terms of having that instilled as part of the medical education, whereby before you graduate as a medical doctor, you are going through what we call the medical ethics. Going through that, I think it's a 3 weeks program, 3 weeks course, whereby it's all part of your final exams, whereby you go through the Hippocratic Oath, understanding patient rights, understanding your obligation, your obligation as a doctor. We call it the Hippocratic Oath, the obligation as a doctor to a patient. Thank you very much.
Thank you, Dr. Muoghalu. I like the way you talked about patient awareness, that information when you get to the hospital to know, okay, if something goes wrong, how do I seek redress? Who do I talk to in the hospital, and what are the next steps? I think it is very important and will help, the country move forward. I just want to give Dr. Onyia 1 minute to make the comment she wanted to make on the medical profession and shielding their members. Dr. Onyia.
Okay, thank you for giving me the opportunity to talk. So the thing is, we must make a difference between negligence and error. Remember, I said repeatedly, it's human to err. So negligence, I checked while I was waiting, is a failure to take proper care over something. I think, I think that's very fundamental. Very often, what is happening is social media just goes to town. Somebody, a patient, a doctor, a practitioner is being judged already. At that point, it becomes very difficult as a colleague to weigh in against your colleague if you're not convinced yourself that there was negligence. That's number one. And then the second thing is that somebody alluded to the fact that there's a dearth of medical personnel in Nigeria. There are very few of us. Even Dr. Muoghalu spoke about the fact that there are only 15 people on the council who are responsible for this issue. There are not enough healthcare practitioners in the country, and people are stretched. And those things must be taken into consideration if we continue to abuse social media. Social media is now being abused against healthcare. For example, you say to a patient, there's no private ward. I'll put you on social media. Everything now goes on social media as medical negligence. We must be able to establish that indeed the duty of care was not met beyond just wanting to demarket a hospital because you think you can. Recently, a patient reached out to me, a patient who I managed the child after the child was born in another hospital and suffered some injury and wanted to go to court. I wanted me to be an expert witness. I offered immediately to arbitrate. I didn't refuse, but my first duty to the patient and to my colleague was I said, let me arbitrate. I said, write me a message. Let me forward to the owner of that hospital and let us see what he will do. And it's still ongoing. So no, we don't refuse, but we will not, the first thing I will do will not be to jump to court to go and throw my colleague under the bus. No, absolutely not. But we will also not cover up or pretend it didn't happen. So arbitration is a way out. We must remember that the legal system is not the only way out. That should be only the final arbiter, I think. It's expensive, it takes a long time, and in the end, I'm sorry I'm talking to lawyers, but luckily also arbitrators. In the end, it does more harm than good. Thank you.
Thank you so much, Dr. Onyia, for that comment. And as you say, actually the court system is not the only way to seek legal redress. There are other alternative dispute resolution methods like arbitration and mediation and just old-fashioned negotiation and talking between the parties. So I'd like to move on to Mrs. Arowolo. Thank you for being here. So on this topic, what would you say are the effects of pursuing claims for medical negligence in Nigeria, both on the medical profession and society in general? What are some of the effects? I think Dr. Onyia has talked about social media. What else are some of the other effects?
Okay, so thank you so much. So some of the effects of hospitals has like several risks. One of which is litigation that was earlier spoken about. The patient can decide to either file a civil suit or a criminal suit. And there's also reputational damage. The risk of loss resulting from damage to one's reputation. There's loss of revenue, capital or regulatory costs. Then there's also destruction of shareholders' value from the hospital's end. Then consequence to an adverse or potential criminal event, even if the company is found guilty. So there's the risk of reputational risk, and there's also the risk of litigation, going to court.
Thank you, Mrs. Arowolo. Although I think some of my colleagues on this platform would argue that if someone has been negligent, then the reputational risk follows suit. But I take that. I mean, not everyone in the hospital has been negligent, so it's sometimes a bit unfair that every other member of that hospital has to suffer for one person's negligence. And also, I mean, in the agency you're working and your experience, what would you say maybe is the attitude of Nigerian courts and judges to treating cases touching on medical negligence? How have you found their attitude to these kinds of cases?
So for medical negligence cases, it's a bit more difficult. And someone earlier spoke about the issue of expert witness. So it's always very difficult getting an expert witness in most of the cases, which is actually fundamental. It's actually very fundamental in any medical negligence case. So for medical negligence, the first thing the court will want to hear is from an expert witness who is actually going to put the court through as to what happened and the standard that is to be expected, and if the person is actually has failed short of those standards. So the courts really like the need for an expert witness in proving medical negligence cases is actually a very big problem. But yes, so the courts actually have, usually to most courts will also recommend alternative dispute of resolution, which includes mediation. So like for Lagos State courts, they will actually send you to the Lagos State multi-door courthouse to see if parties can resolve the matter amicably before coming back to court for trial. So parties are actually encouraged to either settle out of court. Then if you have to come back to court, it actually needs to be proven, and you need an expert witness to do that. Thank you.
Thank you so much, Mrs. Arowolo. I'm happy to hear that, especially in Lagos State, that the courts are trying to get these cases sorted out quickly, because I mean, there's a lot of stress on the patients and also on the medical professionals. So now I'd like to move to our in-house medical law expert, Duke Nwosu, who's a nurse, a registered nurse, and a lawyer. We've spoken a lot about medical negligence in this panel. I'd like to know, what is the current standard? Because before someone takes a case to court, they need to know, what do I need to prove in order to show that someone, a professional, has been negligent? So what is that standard of proof in Nigeria?
Thank you so much, my Oga, managing partner. First, the evolution of the laws on medical negligence. We must understand first that medical negligence gives you a right, and a right is regulated by law. Rather, a right is actually prescribed by law. And so, if you go down to the jural relations, Orpheus analysis of jural relations, you see that a right is what gives you a kind of an entitlement to sue, evoking a correlative liability from the other party whom you are trying to sue as a defendant, and claiming that that particular defendant has actually trampled on your right. And so out of the statutory laws, because we had this colonial romance with the British, out of the statutory laws that the British had, there came decisions of courts that outlined the duties that are available to a particular patient who feels, duties that are available and incumbent on the doctor, and then entitling a patient whose right has been infringed on to sue. You have duties like duty to provide adequate counseling, duty to warn the patient of risk of treatment and so forth, duty to carry out proper diagnosis, duty to administer proper treatment. These duties are either found in statutory laws, which are laws enacted by the legislature and written down, or found in decisions of courts. So we cannot talk about the Nigerian standard if we've not understood where we are coming from, which is the British standard. In Britain, as of 1957, there came a landmark case that created a rule, the rule of law in Bolam's case. The full citation is Bolam and Fayan Hospital Management Board, decided 1957 by the House of Lords. Now, in that case, Bolam went to the hospital to treat depression, and accordingly, according to the case, those days, the pharmacological methods of treating depressions were not available as at then. So he went to treat depression, and they usually apply electroconvulsive shock. Now they sat him on a chair and applied the shock, and he fell off the chair and broke his pelvic bones. And so he sued, and he was claiming that the hospital should have sedated him, or at least strapped him to the chair to prevent him from falling down and breaking his pelvic bones. And the House of Lords applied a rule, which became the rule of law. That is, this particular requirement you are expecting of the hospital, is it the prevalent medical opinion? Or to say, other doctors in that circumstance, is that what they are expected to do? That created the rule of law. So whenever you sue a medical doctor, the question would be, that thing you are expecting him to have done for you, is it what is obtainable? Is it what other medical practitioners in that line and in that circumstance would do? If that is not the case, then you've lost that. And that was how Bolam lost the case, because it was found that the prevalent medical opinion was not that you should sedate a patient and was not that you should strap the patient to a chair in applying electroconvulsive shock. Then along the line, because of course laws evolve, and as it evolves, judges try as much as possible to add, remove, restructure laws to suit, because actually the law is made for the people and not the people for the law. So in 1998, there came the case of Bolitho and City and Hackney Health Authority. That law created a proviso. When I mean proviso, I mean an exception to the rule in Bolam's case. That is to say, it is not just about what the prevalent opinion is. It is now about what is reasonable in the circumstance. The law added the requirement of logic. So in that particular case, in Bolitho and City and Hackney Authority, you had a situation where a medical doctor was off duty, but then he was called upon to come and attend to a patient who was rushed in on an emergency. And because his bleeper was not on, the battery was low, he couldn't get the signal, and so he did not come. And so later on, the patient died, and the mother of the patient, being entitled, sued. And having sued, she was saying that she didn't care whatever it was that prevented the doctor from not coming, that what she wants is for the court to apply the Bolam's case, which says, in that circumstance, what should be done. And of course, you know, if you apply the Bolam's case, you will convict the doctor in this circumstance. But the court said no. In a circumstance where the young man's bleeper was not on due to his the flatness of his battery, how could he have gotten your message? So you see, in application of laws, when the court finds out that this particular law will lead to manifest injustice, the court will do what? Recline, make some amendments and make some changes. And that was how the proviso was added to Bolam's case, wherein the court now requires that particular thing you have done as a medical practitioner to be reasonable, aside being in conformity with the prevalent medical opinion. And then recently, in 2015, in UK, you had the Montgomery case, the Montgomery and Lancashire Health Board. In Montgomery, you have a situation where a particular woman was diabetic, and being diabetic, she was in her gestational period, she was pregnant, and she was due for delivery, but then the medical doctor did not tell her of a particular risk she was open to, which was shoulder dystocia, an inability of the shoulders of the fetus to pass through the cervix, causing pain to the woman and also causing other ancillary damages. And so after delivery, the child suffered severe issues as a result of what maybe assisted delivery that the hospital had to do and every other thing. And eventually she sued. Therein, she was claiming that I should have been told of the significant risk I was going to be put through. The court looked at the Bolam's case and found out that, well, Bolam is good, but in this circumstance, it may not meet the need of the case. They looked at the Bolitho's case. They said, no, it is good, but it may not meet. Maybe we'll have to create an additional rule. And so the court created an additional rule and added to that particular standard, which says materiality. So the doctor actually, in his defense, stated that he felt the information was not crucial and was not significant to have been given to the patient. He was not saying that it would be adverse to the patient to have known, but that it wasn't crucial enough. And so the court was like, it is not in your place to decide what is crucial or not. As long as something is significant and material to that patient, you must tell that patient. So the patient can have to, decide on other choices to follow. You must be able, being that there is a duty to warn the patient of risk, warn the patient of likely side effects and so on, you must be able to throw it open to the patient. Consent must be informed, and to be informed, it must be a whole and entire and free from vitiating elements. That was how the Montgomery case came in. And then we now have a trifold standard in Britain. You have the standard of prevalent medical opinion, the standard of logicality, and the standard of materiality. And the three forms the tripod stand of standards in Britain. But here in Nigeria, we inherited the Bolitho's case. As a matter of fact, if you go to most, we have a data of We have a dearth of medical law textbooks in Nigeria. But if you go to most published works and the few textbooks that are around, you see that they keep repeating the Bolito's, not Bolito, the Bolam's case. If you also look at decisions of courts, the case of OT and Excel Medical Center, ABI and CBN, in OT and Excel Medical Center, we had a situation where the court of appeal was faced with the problem of interpreting whether anal stretch and SLIS could be defined as surgery. So in that circumstance, they applied the Bolam's case and to say, well, in this circumstance, we do not expect the medical doctor to have informed him that, because hemorrhoid surgery was different from anal stretch and SLIS, and because of that, he shouldn't have, because the patient said no surgery. The patient signed the consent form, but then under it, he stated no surgery, please. And so because there was an indication of anal stretch and he ticked yes to it, the court said, well, he has consented to anal stretch, which is not the same with hemorrhoid surgery. However, if the court had gone ahead to apply the Montgomery case, you would have realized that because it is material, because the patient is not stupid to have written no surgery under the consent form. The patient is a full-blown human being, adult, with full sense, not insane, and well-educated. And so after signing everything and ticking all options, including ticking the anal stretch and SLIS, he said, no surgery, please. At least the medical doctor should have gone back to say, what do you mean by no surgery? The medical doctor should have tried to find out, what should we do? These are the two kinds of surgery available. Are you objecting to all surgeries, or are you objecting to just hemorrhoid surgery? So you find out that we are still applying the Bolam's case as it were, and it is not enough. But then it is our duty as experts in this area, specialists in this area, to educate the court, because the courts do not know, as a matter of fact. We have to educate the court and let the court know that we have moved. The Bolam's case is not the custom furrow. The Bolam's case does not do it all again. We should, at least the people who gave us that particular case, they have moved, and so we should move. That is that for the standard in Nigeria, as it were. Thank you.
Thank you so much, Duke, for that exposition. I think it's really put things in proper perspective, and it has actually encompassed a lot of the things that other panelists have been saying. The most important thing really is that patients need to be properly informed, and that patient education has to be there, because when a patient has the full information, then they can get informed consent. And I would like to go, at this point, I'd like to go to the question and answer the chat box to see if there are any questions in the chat. There is a question here from Prince Chibuzo.
Excuse me, excuse me, please.
Yes.
I think a particular lady, Kemi Olawe, has made several comments, and if she'd like to unmute herself, it would be good for her to ask any question that's still burning. Kemi, are you there? Kemi Olawe. Appears not, so you can take the question.
Okay, so a question from Prince Chibuzo, who's a student of law at the University of Abuja. He says many Nigerians do not know their rights, talk more of medical rights. What do you think is the way forward towards educating Nigerians towards their rights? I would like to give this question to Engineer Okwuolisa, because she has a lot of experience in patient rights advocacy work. So please, ma'am, tell us, what do you think is the way forward to educating Nigerians about their rights?
Okay, thank you once again. I think we have more time now to talk. First and foremost, we have to understand that every one of us is a potential patient. It doesn't matter whether we are okay today, even if we are okay today and everyone around us is okay today, maybe our neighbors, our friends might be suffering. And so directly or indirectly, we are affected at every point in time. The need to educate the patient and indeed all Nigerians, as to their rights cannot be overemphasized. So many Nigerians, when I say so many, I have walked into hospitals several times, and most patients don't even know how to ask a simple question. most of patients, most of Nigerians, when they're in the hospital, they see doctors, nurses as maybe that, is it that they are afraid or what? I don't understand it. They don't even ask, they don't have the nerve to ask questions. Several times, for example, like I always say, it's not always about the doctors. It's first of all about us. Are you informed with the information? Are you informed with the knowledge? Do you really know what your part is in the hospital when you get there? Are you just going there for doctors just to, give you drug, do tests and then do diagnosis, cancel you? You have to understand, as a patient, you have a part to play. You have a part to play. There is 3 desired outcomes of every true patient-centered care system, which we are trying to see if it will work in Nigeria. Better overall experience with healthcare system from every patient that steps into any hospital. Greater satisfaction with quality of care. Greater likelihood of better health outcome. When we are sick and we enter or we get ready and go to hospital, we are going to hospital to get better. But most of the times, we don't even help ourselves. You see, we have to understand that Nigeria, in our healthcare, we have a long way to go. So as individuals, we have to understand this patient bill of rights and see how to help our healthcare professionals. They are stressed, they are pressured a lot. They need to educate the patient. We can't overemphasize it. There is so much to do. Like, for example, we have Patient is King project. It's all about educating. We are trying to find ways to educate every Nigerian about their rights when they get to hospital or when they are sick and find themselves in emergency or in any healthcare facility. And also to see how to talk to our healthcare professionals to start seeing patients, not just as a disease that they are coming just to be treated, but to see them as people first. Patients shouldn't be defined by their diseases. They should be treated with dignity. They should be treated with respect. They should be informed, get involved in all their decisions, all the decisions that are being taken about their health. So many of the times you see medical professionals taking decisions about a patient without even his or her family being carried along, and that is very bad. But when a patient is well informed, well equipped, he or she will go forward and ask questions, get the information, all the necessary information that will help them to make an informed decision to enable them, arrive at a better health outcome and then get home alive and safe. So what we do in our small space in Brain and Spine Foundation Africa with our project, Your Patient is King, is, okay, for example, let me throw a light. When my sister had a brain hemorrhage many years ago that led me into the work I'm doing today, I never heard about brain hemorrhage, and she just suddenly was woken up by a headache and collapsed, and we found ourselves in the hospital. The hospital did not have a neurosurgeon, which my sister needed after she was diagnosed of brain arteriovenous malformation. She was supposed to be, just taken to a specialist hospital, a neurosurgery hospital, but she was not taken to that place. They just told us that she will hardly survive and that she had about, in fact, less than 1% chance of survival. And I was now waiting for a consultant, which they told me that was to come. And after about 3 days, 4 days, we were still waiting for this consultant, who now later showed up. And he now happened to be a general consultant. I did not even know who we were expecting to see. It was now later that I knew that we were expecting to see a neurosurgeon. When the general consultant came, I had to even broke the protocols. I went to where he was consulting in the pediatric ward. I had to interrupt his work. I said, sir, my sister we have been waiting for you for the past 3 days. And I thought you are coming directly to see my sister. It now happened that this man did not even know that my sister was even in that hospital. And he was not apologizing. I had to stop everything that was happening in the hospital, and I told them to discharge my sister. And they thought I was crazy. Yes, they did. And my sister oxygen was removed. It was the highest risk of my life. But I preferred to take my sister looking for solution than staying in the hospital while they waited for her to die, because they were waiting for her to die in the ICU. While they were busy charging me 150,000 every day, knowing that she was going to die, and they were not ready to get us a neurosurgeon she needed, even if that they did not have access to any. We had the right to know that they did not have the medical personnel or the consultant that my sister needed. We had the right to be informed that the hospital did not have the capability to help my sister. We had the right to know that, this is where we might get help for my sister. But we were not told any of that. And we were there just waiting while the hospital was waiting for my sister to die. Why? Thank God my sister today is alive after 5 brain surgeries. Thank God, because I left that hospital and they did not know that my sister would survive, because to them it was the craziest risk. But most Nigerians today are suffering things like that in this system. And doctors are not helping matters. They are not quick to refer patients outside their system when they know that they don't have the capacity to treat this patient or to help the patient. Most of our healthcare institutions, they will ensure that they milk, they will just, based on our own ignorance, they will now take advantage of that and milk the family of every resource that they have. Then when they now find out that nothing again is remaining, that is the time they will refer the patient maybe to National Hospital, just go there and die. This is what we see every day because of the ignorance of our people. We don't ask questions. Doctor, today you are treating me of malaria and typhoid. After a month, I will come back again. You are treating me of typhoid and malaria. After 2 weeks, I am coming again. The same doctor is treating me of typhoid and malaria. I will ask the question, why haven't you asked that doctor? Is it that this typhoid and malaria, can't just go away? Is it just residing in my system that it's every month I must suffer typhoid and malaria? Doctor, is it that you have the right diagnosis or you don't have what it takes to give me a right diagnosis? Is there any way I can get diagnosis that can help me to really take care of my health?
Thank you, Chika. I know you're very Well, we have quite a few questions in the chat box, and I want to close the webinar. I really appreciate you sharing your personal experience, especially with your sister, because I know that's really was very dear to your heart, and that's something that your family struggled with. And I thank God that she's alive. So, Kinebo, please, can you go through the chat box and let's see?
Yes. So thank you so much, Engineer Okwuolisa, for that exposition. It's very, as we've all said in this webinar, it's very important for there to be the symbiotic relationship between patient and doctor, and for them, for the patient to trust the doctor and for the doctor to give full information. Actually, a question came to me a long time ago at the beginning of the webinar, which I would just like to, for Dr. Onyia to respond to, because the question on consent. So in social media, there's been a lot going on now about women's rights, right? And you see so many examples of someone saying, well, they were in labor, their labor was either protracted labor, and the doctor may be advised for a cesarean section, and then the husband denied consent. So I would like, from a doctor's perspective, to know what is really the position. Is it a situation that someone can consent to maybe such a surgery beforehand in case there's any complication? And if at that point where the complication has come up, and maybe the woman is saying she wants the surgery and her next of kin, the spouse, is saying no, can the doctor take that initiative without incurring any legal liability to go ahead with the surgery?
Thank you for this interesting question. Remember, I talked about the pillars of our medical ethics. So there is autonomy. And under the principle of autonomy, the patient, as long as she's Compos Mentis and she's an adult, has the rights. And that's what we will stand by. It's only for children that, in that case, you will have to take the opinion of the next of kin. But then again, like I said, we have another pillar, which is do no harm. So a good example is the case of a child requiring a blood transfusion and the parent, a Jehovah Witness, saying don't give. I think there was a recent case, and I'm sure the expert in your group team will know the names of the case. And the court ruled in favor of the doctor to have transfused the child. So yes, we balance all the pillars of medical ethics. Okay.
Thank you so much, Dr. Onyia, for making that clarification. So, and yes, there is a case, it went all the way to the Supreme Court, where the parents actually sued the doctor after the doctor did the transfusion because they said it was against their medical beliefs. So yes, the doctor was right in that situation because the child's interests outweighed those of the parents. So just looking at the chat group.
I have a direct question from this.
Let me quickly add on that case, MP, please.
Yeah.
Yes, Duke.
That case was actually possible because a legislation permitted that. It wouldn't have been that way in some other states. That case emanated from Lagos State. And Lagos State is always at the forefront of legislations. And so their child rights law permitted that the medical doctor in that circumstance must do that which is in the best interest of the child. And in other states, I don't think that result would be the same because the doctor would be operating without jurisdiction to do so or competence to do so, and that would be ultra virus. So I think we should also push for other states to adopt the Child Rights Act and replicate such positions in their child rights laws so that we can have it uniformed in the states of the Federation. Thank you.
Thank you so much, Duke. Yes, COO, you mentioned the question.
This to me, it was a direct question, and this is saying, thank you for this session. I am particularly interested in medical law and practice in Nigeria. A while back, I was referred to a doctor in Lagos, and in doing my own research on him, I discovered that he had practiced for about 15 years in the United States and was barred because he had an improper relationship with his patient. If not for my research, I would not have known. This man is practicing in Nigeria today. So my question is, what efforts are being made to ensure that doctors who have been penalized, suspended, or barred from medical practice in other jurisdictions do not practice in Nigeria? I don't know who's going to answer that.
Maybe I should take a lead on this question. Thank you very much.
Thank you, Dr. Muoghalu.
So we have the Medical and Dental Council of Nigeria. I think they're somewhere in around Apo, around Apo in Abuja. Very big building, and there is also online. They have an online, the MDCN gov.ng, but also they have a portal where people can submit the application online if you have a complaint against a health professional. The only problem there is that the information there is not rich enough for the public to consume in terms of I checked there recently, is just only 2 doctors that are publicly deregistered or under suspension, not deregistered, on interim suspension. But like I mentioned, and which some of the speakers have also pointed out, is we have very few people on this panel, but also I think what can be done is people have to, follow through with their health professional in terms of being in what we call good standing. This, the Medical and Dental Council provide, apart from the licenses, they also give good standing certificate. Most times, most big organizations, when they are looking out for health professionals, they ask them for that good standing, in which they go back to the Medical and Dental Council to get those good standing certificates. What is missing out when it comes to people having very robust information, which I think some of my colleagues are also found guilty of, that is not being able to provide all the information to the ability of the doctor. I assaulted care outside Nigeria, and sometimes you see the health professional going back again to discuss with you. If it requires looking at the textbooks together, you look at the textbooks together so that you are well informed of whatever ailment you are being treated for, and making that decision yourself. Nobody coerces you to make those decisions. Over to you. Thank you very much.
Thank you so much, Dr. Muoghalu. I think something that has been reiterated several times in this webinar is that the patient needs to be properly informed. So I think that if that is the one takeaway we all take from this, I think it would be a brilliant one, because the only way to reduce the incidences of medical negligence, the only way to know if someone is even being negligent is to be informed. If you're not informed, if you're not like Dise, who goes out to check on her doctor, what has this doctor done in the past, is he even qualified to practice medicine in Nigeria, then you shoot yourself in the foot at the onset. You have to be informed. I want to take one final question before we close the webinar. And there have been 2 people that have been very vocal on the group chat. I think Kemi Olaoye and a Mr. Stanley. I don't know if either of them would like to unmute themselves to ask a comment, ask a question, because they've been very vocal on this chat group.
Hello, can you hear me?
Yes, good afternoon.
Yeah. Good afternoon. I am really enjoying the presentation so far. I would like to ask a single question. Now, when we talk about the issue of medical negligence or error or malpractice, I think all this borders on what should be the proper standard. And now the question I'm asking is this: the proper standard for medical practice in Nigeria, is it different from the proper standard of medical practice in UK and USA, assuming or without considering the type of facility and everything, the way it is done in other climes? Should it be the same way it is done here? Or is this issue of proper standard of medical care, is it limited or based on a particular location? That is my question. Such that if a doctor is found guilty of medical malpractice in the UK, then he can come to Nigeria and do the same thing and he will be exonerated, or it will not mean anything. The standard of practice, should it be the same, or should it be based on location and stuff like that?
Okay, so I think our resident international doctor, Dr. Muoghalu, should take a stab at this question. So what is the standard of care? And does it mean that doctors can, be barred in one country and then move to Nigeria as a dumping ground for, barred doctors? What is the standard of care?
So thank you for that brilliant question. Ideally, in terms of practice of medicine and dental surgeon in Nigeria, which is being regulated statutory through the Medical and Dental Council of Nigeria. When you come to register, you are as part of the background checks they do. They should be able to conduct a thorough background checks of your academic qualifications, but also, like I mentioned earlier, we call it certificate of good standing. If they cannot be able to say that you've gone to accredited medical school, they wouldn't give you license to practice. I guess maybe, I'm not sure that the Medical and Dental Council of Nigeria is fully aware that this particular physician or this particular doctor has been disbarred. But also, it will be interesting to see what has happened, that led to him being disbarred before they can take action. So that is one thing I know that the Medical and Dental Council of Nigeria does. They regulate the practice, of which on a yearly basis, doctors and dental surgeons must renew their licenses in order to continue to provide care to patients. So I think if this is something that is known to them, that particular physician will not continue to practice, because it's part of, they will look at your academic qualifications, but they will also look at your certificate of good standing to show that you are fit to continue providing care to the patients. So I'm not sure if they are aware of this, and these are some of the things the Medical and Dental Council frown at. And also, it's not just the Medical and Dental Council. You have the Nigerian Medical Association as well, also providing that professional ethics training, because they are the ones that provide the continuous medical education, and they also work closely with the Medical and Dental Council to see that physicians are of good standing, they are providing the needed care. But I'm not sure if this person is fully, it must have slipped the Dental Council. But again, it's something that would be nice to see how to flag it up to the Medical and Dental Council, such that someone who is responsible for that professional ethics department continues to provide that oversight for all physicians, all doctors, all dental surgeons in Nigeria. And I think it's also applicable to other councils as well, like for the nurses, be able to do background checks. People that are trained abroad or elsewhere, when they come back to Nigeria, for you to obtain your license, you have to go through, series of, medical exams as well to show that you are fit to provide care, that you understand care in Nigeria, and that you can be able to provide care in Nigeria. Over to you.
Thank you so much, Dr. Muoghalu. So Mr. Stanley, Nigeria is not a dumping ground for large medical professionals abroad. So we have about a minute to go, so I'll give the last word to Duke. So Duke, make your 1 minute comment.
Yes. Yes, part of his question related to standards. He was asking about standard in Nigeria, standard elsewhere. Now, Mr. Stanley, what you must understand is that the standard, if you look at the exposition I did on some cases, especially on Bolam's case, I mentioned the prevalent medical opinion. The standards are found in what is obtainable within a particular geographical location or jurisdiction or country with respect to the health system. The National Health Act of 2014 defined the Nigerian healthcare system, and it comes down from the Federal Ministry of Health down to even tribal medical practitioners. Now, what are the standards? What are the opinions? The opinions can be found as published. These opinions are not matters of conjectures. They are published. Some, assuming we are talking about an opinion on basic health, you'll be finding it in the publications of the National Primary Healthcare Development Agency. You have some published by the Federal Ministry of Health. If we're talking about eradication of neglected tropical diseases, you have, now these opinions as published, a lot of times they draw their content from what is obtainable outside Nigeria. A lot of times, if we're talking about epidemics, if we're talking about maternal and child health, we're talking about PMTCT, that is a prevention of mother-to-child transmission in HIV, most of those opinions are compiled with some of their contents gotten from what is obtainable outside Nigeria. And then when they come into Nigeria, they try to modify it to suit our circumstance and our culture, and also taking into cognizance our facilities. So you cannot say, as a matter of a strict sense, that what is obtainable here is not obtainable there. No, in a lot of times it is obtainable, but sometimes it might be modified to suit our circumstance. And so again, on the issue, I saw a question in the chat box that mentioned the issues of what to do when you have these issues. Please consult a specialist in medical health law or a practitioner or an advocate in that area to put you through, because if for want of time, a lot of things would have been said. The things that happen in the courtrooms, the things that happen in the medical disciplinary committees, and so on and so forth, and the propensity of persons who are doctors who are actually liable, escaping liability because of lack of skill on the other side. Someone spoke about experts and the reluctance of medical doctors to testify against their co-workers. Now, you must not always rely on experts. Expert evidence is not all there is. No, there are cases where you have to suggest written and published work to the judge, and even tender sale. A textbook has been used to convict a medical doctor, a textbook. So it's you knowing your way around. So go to lawyers who are specialists in this area. Come to Compos Mentis legal practitioners. We handle it without waste of time. Thank you. That will be that for that.
Thank you so much, Duke. And I just want to say a very big thank you to all our panelists for taking out time of your busy schedule to, educate the public, because this is a very important area. We're all going to need medical care at one point or time, in our lives. And it's important that we are well informed. It's important that we know that we can trust our medical practitioners, and that our medical practitioners also are confident to give us the information we need to make an informed choice. And so also I'd like to thank all the participants today, the people who stayed with us on this webinar, those who have commented, those who have asked questions. This webinar would not happen without you, and we are indeed grateful that you take out your time to join us on these webinar series. Please look out, we will do another interesting topic next month, which will be published on all our social media handles, which have been published in the chat group. So please look out for our next webinar on another interesting area of law, which will be determined. Thank you so much and have a great day.